Good morning to all. This hearing is called to order. First, I would ask Ms. Danielle Motley to swear in the stenographers. Thank you. In the matter of the Utility Regulations Act, Cap 282 of the Laws of Barbados, and in the matter of the Utility Regulation Procedural Rules as amended, and in the matter of the application by the Barbados Light and Power Company Limited, hereafter referred to as the applicant, for a review of electricity rates pursuant to Section 16 of the Utility Regulations Act. On October 4, 2021, the applicant filed with the Commission its application pursuant to Section 16 of the Utility Regulations Act for a review of electricity rates. Following this filing, the Commission advised the public of the application by way of a public notice and invited members of the public to be involved in the process by submitting letters of intervention. The Commission received 8 letters of intervention and 2 motions for late intervention. The Commission granted intervenor status to 8 parties, namely the Barbados Renewable Energy Association, the Energy Division, Ministry of Energy and Business, Dr. Roland Clark, Tricia Watson and David Simpson jointly, Kenneth Wendt, the Barbados Sustainable Energy Cooperative Society Limited, the Business Development Division, Ministry of Energy and Business Development, represented by Public Counsel, and the Barbados Association of Retired Persons, also represented by the Public Counsel. Please note, Dr. Roland Clark has since indicated his unavailability to participate due to other commitments. The Commission looks forward to the continued contribution of the interveners to this process. Following a request from the applicant to hold in confidence certain pages of its application, the Commission convened a confidentiality hearing and determined that certain aspects of the application should be held in confidence by the Commission. Over the last several months preceding this oral hearing, the Commission has engaged in preliminary work which would ensure an efficient hearing proceedings. Pre-hearing work included a procedural and issues conference so that the parties could agree on the issues that would be determined at the rate review hearing, and a procedural hearing to confirm the dates of hearing. There has also been extensive exchange of interrogatories and requests for information and documents. Along with the Commission, the interveners asked the applicant a series of questions, and the applicant responded to the interrogatories and filed the information or documents requested. Over the course of the next 12 days, you will hear testimony from the applicant's witnesses. All interveners present will be given the opportunity to cross-examine each of the witnesses. Interveners are also permitted to present their own witnesses. It is critically important for the efficient conduct of the proceedings that parties do not stray from the issues that are pertinent to the determination of this rate application. These issues are appended to Procedural Order Number 1 and are as follows: the test year, suitability and methodology, rate base, revenue requirement. At 3 is capital structure. 4, rate design. 5, the disaggregation of the fuel cost adjustment. 6, financial forecasting. And 7, customer refund. Before we proceed, there are a number of motions filed by the applicant and various interveners. The Commission intends to deal with these matters in the following order. A notice of motion dated September 16, 2022, and filed by the Barbados Association of Retired Persons, Inc., for an adjournment and to extend the time limit given by the Commission pursuant to Rule 37(1) and 8 of the Utilities Regulation Procedural Rules 2003 as amended. This motion will be heard jointly with the notice of motion dated September 19, 2022, and filed by the Public Counsel for an extension of time and to amend Procedural Order Number 6. Do note that in the light of the nature of these two motions, the Commission will break to consider the submissions of all parties before giving its ruling on these motions. The outcome of these two motions may impact the remainder of the proceedings. Against this background, and depending on the outcome of the above, the other motions filed may also be heard in the following order. Notice of motion dated September 9, 2022, and filed by Tricia Watson and David Simpson for the Commission to order the Barbados Light and Power Company Limited to amend its application based on the Fair Trading Commission's depreciation decision dated March 25, 2022. 3. Notice of motion dated August 22, 2022, and filed by the applicant to amend the issues list pursuant to Rule 34(7) and Rule 8 of the Utility Regulations Procedural Rules 2003 as amended. 4. Notice of motion dated September 16th and filed by the applicant to amend the procedural order dated August 26, 2022 to permit BLPC's expert witnesses to virtually participate and give testimony in the hearing of the application pursuant to Rule 8 of the Utility Regulations Procedural Rules as amended. 5. Application dated September 16, 2022, and filed by the applicant to permit the applicant to give evidence via a witness panel in the hearing of the application pursuant to Rule 21 of the Utility Regulations Procedural Rules 2003 as amended. 6. Application dated September 16, 2022, and filed by the applicant for an extension of time for filing witness statements in Procedural Direction Number 6, pursuant to Rule 7 of the Utility Regulation Procedural Rules 2003 as amended. And 7, a request for confidentiality submitted by the Barbados Light and Power Company Limited for pages 490, 491, 492, 493, and 494 of the application to be held in confidence by the Commission in accordance with Section 11 of the Fair Trading Commission Act, Cap 326B, and Rule 13 of the Utility Regulations Procedural Rules 2003 as amended. The Commission panel for the hearing as follows. I am Dr. Don Carrington, hearing chairman. I have Mr. John Griffith, Commissioner, Ms. Ron Martinez, Commissioner, Dr. Anki Scott Joseph, Commissioner, and Mr. Samuel Wallison, Commissioner. The Commission is represented by the following staff members: Dr. Marcia Atherley Ikechi, Chief Executive Officer, Mr. Kevin Webster, General Legal Counsel and Commission Secretary, Ms. Daniel Motley, Legal Officer, Ms. Kathy Ann Bell, Acting Director of Utility Regulation, Mr. Elvis Cadell, Electricity Analyst, Mr. Stuart Carter, Financial Analyst, GDS Associates, Inc., Consultants, Mr. Ulrich Scott, KC, External Counsel, Mr. Roger Ford, KC, External Counsel. Parties are reminded to conduct themselves in a respectful manner. Conduct that is contemptuous by any person appearing at this hearing shall be grounds for excluding that person from the proceedings. When parties are making submissions, all other persons in the hearing room should remain silent. Persons wishing to retire from the hearing should wait until an oral submission has been completed. The panel shall control the pace and flow of the hearing and should do all that is necessary to ensure there is a smooth and efficient flow of proceedings. I now invite all parties to enter appearances.
Good morning, everybody. I am Sharon Dean, Public Counsel Acting. With me is Ms. Jamila Eastman, who is the Legal Officer in the Office of the Public Counsel.
Good morning, Mr. Chairman and members of the panel. I am Tricia Watson, attorney at law. With me is co-intervener, Mr. David Simpson.
Okay, Samantha, good morning, everyone, chair, panel, fellow interveners, and the members of the public and press. My name is Samantha Cummins, Chief Legal Officer, Division of Energy, Ministry of Energy and Business. There's one other person that is with me, but he's running late, and his name is Mr. Alton Best, economist. Thank you.
Good morning, Chair, and good morning to all. My name is Stephen Worm. I'm the Vice President of Barbados Renewable Energy Association. I'll be representing the association along with our president, Mr. Robert Goodrich, who's here with me.
Good morning, Chair. I'm Kenneth Ricky Went. I'm Regional Vice President of Axel Finance, but I'm operating in the interest of the public. With me is my team. Is Tony Gibbs on my right, as well as Adlai Stephen on the further right. Unfortunately, a member of my team, Dr. Ali Alfar, who is currently in Egypt, we're waiting the outcome of the decision as to how he will be able to participate. Thank you.
Good morning, Mr. Chairman and members of the Commission, other participants. My name is Trevor Brown. I'm the Chairman of the Cooperative Coalition, and I'm accompanied here by my deputy, Mr. Hally Haynes. Thank you, sir.
Thank you. We will now proceed to hear the first two motions. A notice of motion dated September 16, 2022, and filed by the Barbados Association of Retired Persons, Inc., for an adjournment and to extend the time limit given by the Commission pursuant to Rule 30.7.1 and 8 of the Utility Regulations Procedural Rules 2003 as amended. This motion will be heard jointly with a notice of motion dated September 19, 2022, and filed by the Public Counsel for an extension of time and to amend the procedural order number 6. I now call on the Public Counsel to make her submissions on the motions.
Good morning again to everyone. Just now when I introduced, I should have also introduced Ms. Marilyn Rice-Bowen, who's representing the Barbados Association of Retired Persons, normally known as BARP. I also wanted to make a slight adjustment. I'm not sure if this was said earlier, but the motion is actually for the grant of an adjournment as well as to extend the time limit given by the Commission pursuant to Rules 30.7.1 and 8 of the Utilities Regulation Procedural Rules 2003 of the laws of Barbados. In support of my motion, it is necessary to remind you of the twofold role, the twofold statutory duties that I have as an attorney at law and public counsel under the Utilities Regulations Act, Cap 282, Section 9. I'm supposed to, the public counsel must represent the consumers. She's also representing BART as well as the ministry and the Small Business Association. It is necessary to also say that as an attorney at law, under the Legal Professional Act and the Code of Ethics, it is necessary to defend the interests of my clients robustly and assiduously. The Fair Trading Commission must also be reminded of its statutory duty to safeguard the interests of consumers, to regulate utilities and to regulate utility services. I'm also going to continue by saying that the Commission must also carry out its functions in such a manner as to promote efficiency. Having set out these twofold statutory duties that exist, I must now emphasize the following. The Fair Trading Commission has known from as early as July 27th, 2022, they were given notice that the then public counsel, Ms. Alison Burke, was incapacitated by serious illness and was currently on sick leave until August 15, 2022. This ensured that she was incapable of meeting any procedural deadlines or communicating with her clients and performing her statutory mandatory duties in accordance with Section 9 of the Utilities Regulation Act, Cap 282. Furthermore, there was additional notice at the procedural hearing of Monday, August the 22nd, 2022, at 10 a.m. via Zoom. The transcript shows that Ms. Burke was still on sick leave, and there was no set return date at that point. It was against that backdrop that the FTC still ignored all this information, almost forgetting their statutory duty to protect consumers, and still set the hearing down for September the 21st. At this point, they were unaware, unsure, and against all reasonableness and to the prejudice of all the consumers as well as BART, they were unaware at that point as to whether the public counsel was going to return, whether, in fact, as we note to date, she still has not returned. And I took up the post on Monday, the 19th of September at 8:15 a.m. On my second day of office, in fact, today would be my third day of office, I do not have all the information relating to the rate hearing. I do not have all the interrogatories. I do not have all the responses to the interrogatories. And even if it is suggested that all this information may have been sent to the public counsel, the former public counsel, or sent to the ministry, it is clear that the volume of the information is so much. I've started reading, and the first document I started to read was 1,300 pages long. As I continued to attempt to read and to digest, to understand, and to be able to properly advise my clients, as well as to be able to properly present my arguments before this tribunal, as I continued to read, I realized that it was probably about 3,000, in excess of 3,500 pages of documents. And all these documents are technical documents. So even if there is the suggestion that all these documents may have been sent to the public counsel or to the office or to the ministry, I have not had sight of the same. And even if I could have gone through every single document, it would not have been possible to be ready in basically a day to present proper arguments to fulfill my statutory duty. The public counsel post is not just, it's a creature of statute, basically. It's not just a willy-nilly post. It's a creature of statute which, under the Utility Regulations Act, it's clearly set out the duties of said public counsel, which are to represent the consumers at rate hearings, basically, and present arguments. I would even go as far as to say that there are many attorneys at law in the room, and I would be bold enough to say that none of the attorneys in this room, with one day to absorb and to have a full understanding of all the information, all the technical information, would not do the same thing that the public counsel is seeking to do. Any competent attorney, in fact, I would go as far to say even an incompetent attorney, would in fact seek to have an adjournment, which is what I'm doing today. The reality of it is, the Fair Trading Commission, as well as the Public Counsel, we have statutory duties, which in order to carry this out properly, the only fair, just, and reasonable approach would be to allow us the adjournment so that we can properly prepare, properly be able to assist the consumers, be able to assist our clients, Barbados Association of Retired Persons, the Business Development Unit, as well as the ministry, and to be able to carry out the mandated statutory duties. I'll also suggest that it is necessary for us to be able to, we're actually representing about 200,000, there's about more than 200,000 persons in Barbados. And this statutory duty which we hold, you'll hear me constantly emphasizing this, because the role of the public counsel is extremely important. This is a matter of national interest. It is a matter which the public is very concerned about. And at the end of the day, the transparency of this matter, which currently is being streamed, the reporters here, it's of national interest. And if we're serious about being fair, ensuring that justice is carried out, ensuring that there's a reasonableness and these proceedings are extremely transparent, in order to ensure this, it is absolutely necessary that public counsel be provided with an adjournment. and extension of time to ensure that documents are properly perused and that the job can be properly done. I'll also suggest that to provide, if there's a failure to provide public counsel with this adjournment, it would result in disastrous consequences. To me, it sends the wrong message. If we are interested in justice, fair play, and reasonableness, there's no attorney at law in this room that would, I dare say, would be able to present a case with the 3,500 pages, and that's just the beginning. Having come into the matter on Monday, the 19th of September at 8:15 a.m., I dare say it would be impossible to be properly prepared to present any arguments that would make sense and that would protect the consumers and that would represent my clients properly. I would also say that it must be said that the Office of Public Counsel is not staffed with 1,000 other attorneys that could possibly pick up the slack. There is just the Public Counsel, and there's also a legal officer. And I must add as well that the legal officer only basically took up duties perhaps a month ago, I think maybe even to get involved in this actual matter was basically only a week or two, a week, basically, 1 week. So you're basically looking at a situation where you have the Office of the Public Counsel with literally a day to consume all the relevant information. My concern is that a failure to provide us with this adjournment creates a situation where it is almost an abuse of a discretion. Because as any attorney knows, anytime you ask for an adjournment, there's always the possibility you may not get it. But you also know that even in superior courts, such as, say, CCJ, say, the Court of Appeal, the Supreme Court, superior courts to a tribunal, were we to be in this situation where you've just received a case 1 day before the actual hearing, an adjournment would 99.9% of the time be granted. Because if it is we're interested in justice and we're also interested in the general public of Barbados who are consumers, those are the ones that the Public Counsel represents. And in a situation like that, I believe the only reasonable, sensible thing that can possibly be done would be to grant the adjournment. I also would say that, to me, if there is a failure to grant the adjournment, and as I said before, such an adjournment, I do believe, would be granted in superior courts to this tribunal. And I also want to say as well, if there's a failure to grant this adjournment, it would almost be tantamount to something I consider to be regulatory capture. To explain what that is, regulatory capture suggests that there's no fairness going on. It's almost as if the parties are involved. There's no transparency. All the parties are operating together without the actual transparency that is required for such an exercise. To further, perhaps if I need to explain it a little bit more, it is when you have a situation where a rule maker or a policy maker does not necessarily serve the interests they are supposed to serve. It's almost as if they serve different interests. And as I said, I'll repeat again, I just said it would be tantamount to that if the adjournment is not granted. I also want to say that, to me, it would be unconscionable and an exercise or almost a misuse of the exercise of the discretion if the and this also prejudices the consumer, and it prejudices the Barbados Association of Retired Persons. To my mind as well, there's no prejudice to BLPC if there is the adjournment, because I think very recently an interim rate was afforded to them. And they were properly represented by their attorneys. This is a situation, again, I repeat, where the Public Counsel came into the actual picture on Monday, the 19th of September at 8:15 to 8:30 a.m. I also continue to say that in my 30 years of practice before tribunals, before inquiry panels, before superior courts such as the Supreme Court and the Court of Appeal, in any situation like this, where the matter is of a complex nature, the matter is not simple by any means. As everyone knows, rate hearings are not, they're not just basic. We're not in court trying to get a simple divorce where the persons don't even have a house and they don't own anything. This is a complex matter. It's a matter which, actually, this matter was going on for more than 11 months. And I'm sure BLPC and the other players in the market had time to consider all their arguments, consider what they were going to present, and basically, they were able to equip themselves properly. And I'm saying that it is absolutely necessary to ensure that the Public Counsel is in a position where she can properly, adequately represent her clients and also carry out her mandatory statutory duty as both an attorney at law and as Public Counsel. I trust that, I also would want to add that even my cursory attempt at examining the information, I'm well aware that we are not in possession of all the documents. We also do not have some responses to some interrogatories. We also are not fully equipped with all the technical information. And to this end, again, I respectfully request that in the interest of the public, in the interest of the transparency of this proceedings, and in the interest of fairness, reasonableness, and ensuring that there's not an abuse of the discretion which the Commission holds, I again request that we be offered an adjournment, at least for 2 months, and also an extension of the time limits to file the requisite documents. As I said, in my cursory attempt to peruse all the information, there were some documents that we were unable to file because there was no one in the actual post at the time the filing was required. And I again repeat, there was notice of the fact that there was no one in the post to carry out the job. There was no one there. So in all fairness, transparency, I again request that we be granted the adjournment and also to be able to extend the timelines so that we are able to file all the requisite documents. I would also like, at this point, to ask if it is possible that Ms. Marilyn Rice-Boeing would be able to say a few words in respect to the Barbados Association of Retired Persons. I do know you've joined both motions together, but I think it would only be fair that she has an opportunity to, say a few words on behalf of the Barbados Association of Retired Persons. Thank you.
In this matter, you indicated that you were representing the Barbados Association of Retired Persons, so you speak as counsel for the association.
Sir, with all due respect, but it's, she has her own separate motion, even though, because Public Counsel has a motion, and so does Ms. Rice-Boeing as, in respect to the Barbados Association of Retired Persons. So I think it's fair if she's allowed to speak. But it will be your decision, sir.
You did indicate, but on this occasion, if she could just for a few minutes make the presentation.
Thank you, sir.
Thank you very much, Mr. Chairman. And I will be indeed very brief, because there's not a lot I can add to what Public Counsel has said. But I want to reiterate the importance of examining our motion for an adjournment in the interest of fairness and justice, particularly to the seniors of this country, because this is, of course, Senior Citizens Month, and there's one government agency, People's Empowerment Ministry. They are doing their utmost in ensuring that elderly rights are indeed protected. And on the other hand, we have FTC almost appearing to snuff out the rights of the elderly. I want to use, permit me to use an analogy like, you're standing in line, a senior standing in line, and somebody wants to get ahead, so just push them out of the way and stand in front of them. And all we are asking for as seniors, as parents and as grandparents and of this country, persons who have built this country, we are asking, sir, for the Commission to consider our motion for adjournment to ensure that fairness and justice will be granted, and that at the end of the day, that access to justice will not be denied to the seniors, sir, of this country. That's the end of my submission.
Thank you. I now invite the applicant to make submissions on these motions.
Thank you, Chair. Chair, on August 22nd, the Commission would have held a hearing where it delved into and made every effort to ensure that all parties would have an opportunity to be heard. The Commission balanced its obligations, which, like the Public Counsel, are of a statutory nature, owed to consumer and applicant alike, and made a determination that in terms of the different interests, the present dates that have been set for the hearing would be the most reasonable. And we stand with the Commission in that assessment. It is of note that during that hearing, you were at pains, Chair, to accommodate, listen. It was indicated at that time that the Public Counsel was unavailable. And I believe at lines 161 to 164 of the transcript of that proceedings, you would have indicated to Ms. Cummins, who would have indicated the situation, that these dates would have allowed some ability for the parties to put their house in order, indicate to the Commission their needs and how the dates would affect them. It is also of note that by procedural direction 6, paragraph 16, this commission specifically indicated to all parties that they are to have multiple representation in terms of the nature of these proceedings. And obviously, the logic of such a direction is clear. These proceedings, yes, are of national interest and importance, but the fact remains that the individual needs cannot trump the national needs. We note that the Ministry of Energy would have filed a motion requesting an adjournment in this matter, which was withdrawn. And I understand and I believe that in the context of what I've just said, that was the appropriate thing to do. I understand the difficulty my friend finds herself in relative to her timing, but a quick look at their website, Chair, as to who they are, and we must remember that the Public Council is an office, it's not an individual. It operates, yes, with statutory obligations, but the title public office council is not an individual. But the office of the Public Council is staffed by 4 highly proficient and dedicated individuals trained in the functional areas of law. That's the first line in who the office is. And certainly that would suggest that they would have been in a position to follow the Commission's direction at procedural direction 6 in terms of setting up their representatives. Certainly since August 22nd and the indications by this Commission as to the necessary dates, the powers that be were in a position to ensure that an appropriate officer was put in place in time and in such a manner that they would have been able to handle the proceedings. The reality is that every delay in this matter has costs which unfortunately at the end of the day are passed on to the consumer by the nature of their obligation to carry the costs of these proceedings. The reality is also that this date of hearing was set for August the 25th to September the 9th, has had to be adjourned on that occasion to the present dates, has meant that expert witnesses and the like have had to rejig their obligations to facilitate the hearing. In reality, it's the reason why the applicant is now placed in a position of having to make the motion requesting permission to allow some of our expert witnesses to do their testimony virtually after they had planned to be in here in person, as would be the norm and is the requirement. That is, all parties are doing what is necessary to facilitate this hearing, even where there are inconveniences to them, even where there are costs attached to it. Reasonableness in this manner and balanced by the Commission has to be dictated by the fact that, as my friend has indicated, these proceedings have gone on for plus 11 months into a year. It is high time that they come to a conclusion. It's a high time that the statutory duty owed by the Commission is carried out for the benefit of the Barbadian populace. Also, reasonableness in assessing the position of the interveners who make the request should be assessed by the nature of the interrogatories that have been filed, an assessment as to who has filed interrogatories, what matters have been requested in terms of clarification. And we know that the interrogatory process has been long and involved with extensions of any number of times. The question the Commission has to ask itself is whether it believes it has given enough opportunity for parties to be represented, make their efforts to clarify the details in issue, and whether in the circumstances it can have a fair and just hearing. And I believe that those things have been met. There is a change in the context of how our lower courts function. Reference has been made to superior courts in this land. And the reality is now that our courts indicate, especially in the context of ensuring that justice is done, is that when hearings are set, they are set. This Commission has already facilitated adjournments on numerous occasions, on any number of matters. And I am certain you are well able to represent yourself. But the suggestion that this commission has in some way been unfair or is not recognizing its statutory duties, which are myriad and must be balanced across the line, I don't believe is just in the circumstances. There is significant data before the Commission to suggest that it is ready, able, and that no party or member of public of Barbados will be disadvantaged by a hearing if it was to continue today. And we strenuously object to the requested adjournment. It will result in delays, costs, and a failing of the Commission to meet its statutory duty in the context of all of those factors which affect reasonableness. Thank you.
Thank you. I now invite the Barbados Renewable Energy Association to make a submission on the motion.
Good morning again, Chair. Anytime there is a change of something as significant as this, where there are so many people involved, where there are so many different activities that have to be sacrificed to appear, not only appear here, but also for all of these subsidiary things that take place around it, makes it a very difficult situation for a change to be made at the last minute. We, however, do understand, the dilemma that we're in, because we have taken quite some time to get to this stage. I think the Commission and all involved have taken pains, sacrificed time and effort to get us to this point. The Public Council is, however, a very important part of this process. I think, as it has been identified, is actually in the law about their participation here. But if they are not represented or did not participate, there are other interveners who are here. I think all of us have the interest in finding the right solution for Barbados, and all of them have different sort of things to bring to the table. And I think that, looking around the room, that's where we have tremendous value, where everyone brings a different, or some different perspectives that will help the Commission get to the end. So we do believe that the Public Council is a very important part, but with or without, I shouldn't say without them, but I think participating as they participate, there will still be value. However, I would like to say that to me this is more of a legal issue, and I do sympathize with Intervenor Dean on behalf, who's representing Public Council, and Bart, that if they were not allowed to participate, there would be, in the way that they should, that there would be a perception of lack of transparency. And I think these are things, I do understand Light and Power's perspective, because this has really gone on for a long time, and I think, all of us had hoped that it could have been addressed. I know a lot of discussion has taken place on the length of time that it has taken us to get to even the first stage in the process. So we do believe that, there are a lot of things to weigh, and it is a bit of a dilemma, but from Bria's point of view, I'm also a member of BART, by the way, but from Bria's point of view, we do think that the Commission, having heard the different arguments, would find a solution. We don't have the solution. We just believe that it will be a problem for many to make a change, and it will be a problem if we don't make the change. So we have to find and see how we can best balance both of those. And I do believe it also is a legal issue, that in terms of the law about the representation and proper representation that could be given by the council, Public Council. So from our point of view, we would leave it to you, and we look forward to working in whatever way we can with any decision that you make.
Thank you. The Energy Division, Ministry of Energy and Business Development, Ms. Cummings.
Yes, good morning, and thank you, Chair, again. In my submission with respect to the application, the motion, I must say I have to support public counsel, not only as an attorney at law, but also as a member of the public, and as an officer of the court, well aware of the principles of natural justice. Now, I have heard the submissions on behalf of the BLPC, and although, well, their interest has to be ventilated, I also agree with the public counsel that they are not too much at a disadvantage because the commission has granted them an interim rate to take care of what we call regulatory lag. So while we are here debating and while we're here presenting our case, BLPC still has a ruling from the commission that will help them till we get to the end of the substantive matter. Apart from that, the public counsel is a creature of statute. And why was it necessary to create that post under statute in the Utilities Regulations Act, Cap 282? I believe, sir and panel, that strictly was because someone saw the necessity to have a person there to represent the consumers, and especially the consumer who may not have the affluence to be able to pursue matters such as these. So they have a public advocate who can represent their interests. Now, that being said, it is only right that that person who has that statutory power, that statutory duty, is given the opportunity, reasonable opportunity, to be able to carry out that function. And the particular circumstances under which we find ourselves here, sir, is that the previous public counsel is ill, very ill. I know Mr. Aline, my learned counsel, my learned friend on the other side alluded to the fact that, you know, the public counsel is an office and not an individual. But, sir, it is a public office, and times they're not filled with the officers as they should be. So really and truly, at the time that Ms. Burke got ill, there was neither a public counsel nor a legal counsel. Now, when you take all these extenuating facts into consideration, it is only fair, as any attorney at law sitting in this room would have to admit, that the person be given time to properly take instructions, to properly go through the information, to ensure that all matters and directions given by the commission have been complied with, and to prepare those representations and submissions on the behalf of the client. It just so happens that it is public counsel, but were it the Ministry of Energy, and dare I say, were it the BLPC, the same thing would have happened. I note that counsel for BLPC, they have at least 2 or 3 attorneys supporting the principal counsel. But unfortunately, in the public service, we don't have that luxury. Hence, that is why we find ourselves where we find ourselves today, sir. And I note that Mr. Allen had also referred to the fact that, you know, the office of the public counsel is an office and not an individual. right? And that the commission had already given directions that you should have one other person. But we must also note that the rigidity of the law must be balanced with the spirit of the law. That is reasonableness and fairness. And I also believe that the integrity of this whole proceedings, its transparency, and the deliverance of justice must not only be done, but must be seen to be done. And part of getting there is to ensure that all parties have been given equal opportunity under the law to do what they have to do to make the best presentation that they have to represent their client and make their submissions. And with that, sir, I end my submission. Thank you.
Thank you, Ms. Cummins. I now invite the Tricia Watson, David Simpson intervention teams to make your submissions on the motion.
Thank you, Chair. Learned Counsel, Ms. Dean, has very clearly articulated the statutory duties of the Public Counsel. That Public Counsel exists to represent consumers in a rate hearing before the Fair Trading Commission bears repeating, however, and that Public Counsel is mandated to represent consumers, also mandated by statute, also bears repeating. In that respect, I wish to point the panel to Section 8 of the Utilities Regulation Act and to remind the panel that the post of Public Counsel is deemed so important in Barbados that the holder of that post is appointed by the President of Barbados. Section 8.1 of that provision says, a public counsel appointed by, now President, acting on the recommendation of the Judicial and Legal Service Commission by instrument in writing shall perform the functions set out in Section 9. Even the panel hearing this request and the Commission is not accorded such status in Barbados law. The Utilities Regulation Act and the Fair Trading Commission Act must, as a matter of law, be upheld by the Commission and by any panel of the Commission. And the Utilities Regulation Act, at Section 9, states the following. A public counsel shall, A, advise consumers on matters relating to this act, and B, assist consumers in preparing for reviews and hearings and presenting arguments before the Commission in relation to the setting of rates. It goes on to say more, but I will end there. The Commission has no choice, in our view, but to do all that is necessary to ensure that the Public Counsel performs that role that is mandated at Section 9 of the Utilities Regulation Act. I will also refer the Commission to Section 4.5 of the Fair Trading Commission Act, which specifies that the Commission shall do all that is necessary and expedient for the proper performance of its functions, and those functions include protecting the interests of consumers in Barbados. It should be obvious to all that it is in the interest of consumers that they be properly represented by the Public Counsel which has been established to perform that role, regardless of whether they're interveners or not. On that point, I want to respond to the submission of BRIA, and which suggests that because there are other interveners here, that is enough. We do not have a statutory role that we are obligated to perform. Public Counsel does, as does the Commission. We all are here representing consumer interests, that is true, but we are not obligated to do so. Therefore, interveners could make a decision to discontinue a matter, their involvement in the matter. Public Counsel does not have that choice. I will go on to say that the Public Counsel, having already outlined why we find ourselves here, every party here is aware that from the middle of July in this year, the Commission was made aware that the then acting public counsel was on extended sick leave. That's nothing to brush aside. And when the procedural conference was convened on the 22nd of August, the Commission was again reminded by counsel that the public counsel was unavailable to indicate whether the dates being considered were workable. And that is something that the Commission needs to take into account. That was flagged to the Commission. Astoundingly, though, the Commission, after accommodating all of the requests of the Barbados Light and Power, forged ahead and set dates, ignoring the implications of public, in my view, our view, of public counsel's absence. In fact, this team itself found that it may have been halved, notwithstanding that the Commission keeps saying have at least 2 people. The Commission set dates and then responded to our correspondence indicating that the Commission had prevented Mr. Simpson from indicating his dates by saying it is enough for one of your parties to have spoken. And so the Commission itself needs to consider that, notwithstanding that it indicates that there should be at least 2 members of the team, itself acted in such a manner as to prejudice this team. I emphasize that the Commission was aware of public counsel's extended absence, not just the absence from one meeting. It was aware of the absence in relation to submissions and in relation to its the council's availability for this hearing to commence today. The Barbados Association of Retired Persons, represented in this hearing by public counsel and by the president of the association, is one of 2 large consumer bodies represented in this matter. And their involvement in this rate case aligns directly with the mandate of the Commission set out at Section 4.4 of the Fair Trading Commission Act, which requires that the Commission consult with consumers and consumer groups. BARP is a consumer group at the end of the day. The company, Barbados Light and Power, has said a lot about delays. Let us be clear about the source of delays in this rate proceeding. The Barbados Light and Power has delayed by refusing to answer the interveners' initial interrogatories, citing a requirement for the Fair Trading Commission to direct them to answer. There is no such requirement in our law. Our law requires that the company answer interrogatories within 60 days of the application. And while we take the point that 60 days had passed by the time that the interrogatories were forwarded to the Barbados Light and Power by the Commission, it must be obvious that there were that the company, if it was interested in speed and expedition, would immediately have commenced answering those interrogatories when they received them in March 2022, rather than sitting down on those interrogatories for several months to only start answering in July, and even having started answering those interrogatories, has failed to answer relevant interrogatories and has presented their answers and information in such a manner as to prevent interveners from handling that information in a manner that would assist us in preparing our cases and analyzing technical information with efficiency. I think that is a matter that we cannot overlook. We are still contending with that today. And frankly, the Commission has not helped us with that issue because we have requested a technical conference to address that, and the Commission has also denied that conference, a conference that the law contemplates to allow us to settle matters related to interrogatories, technical matters, to allow us to agree matters that we're not in disagreement about, and the Commission has itself failed to utilize that mechanism to allow us to address this interrogatory phase with speed. Therefore, it is disingenuous for the company to talk about delays when the company has not acted in a way that suggests that they're interested in alacrity in this process. The Commission itself has, in our view, exacerbated that problem and contributed to the much-touted regulatory lag by failing to direct the Barbados Light and Power, one, to answer the interrogatories, even though interveners have pleaded for months for that to happen, and by concentrating on an interim rate relief process that the law does not recognize, rather than dispensing with that matter at the outset and going straight into this hearing. This hearing could have started at the beginning of this year rather than starting now. We support Public Council's observations about the asymmetry of resources. Again, Barbados Light and Power has no less than 6 council working for 11 months in this matter. We are now facing the situation where Public Council has 2 council working for, in one case, 1 day, in another case, just a few days, and in an effort to ready themselves for this hearing. In addition to that, the council, official counsel for the Barbados Light and Power, is a law firm of at least 30 attorneys, as far as I'm aware. Therefore, they have the resources to prepare for this matter speedily. And we also cannot forget that the parent company of the applicant is a global company with no doubt thousands of people resources and billions of dollars to afford them the opportunity to purchase resources. Again, that is not available to the Office of Public Counsel, which obviously must operate within a set budget set by the government of Barbados. The intervener team of Watson Simpson has repeatedly asked the Commission to proceed with this rate hearing. And we would not, however, be true to our philosophical grounding as interveners if we did not support the request for an adjournment by the state's consumer advocate, that being the Public Council. For the record, in the interest of natural justice and in observing public law and administrative justice principles, and in that regard, I direct the Commission to the Administrative Justice Act. That would be very instructive in making your decision. We support the motions of Public Counsel and the Barbados Association of Retired Persons. We support them unequivocally for an extension and an adjournment and all of the other orders that are set out in the motions filed by BARP and by the Office of Public Counsel on the 19th of September 2022. I'm obliged.
Thank you for your submission. I now invite intervener Kenneth Wendt to make his submission.
Thank you, Mr. Chairman. The hearing indeed has been going on for some time, but even here this morning, Mr. Chairman, you have asked us and pointed out that the Barbados Light and Power Company itself has now bring motions even to do what? Look at the confidentiality hearing that we would have had before.
Mr. Wendt,
We've also,
could I
Mr. Chairman,
ask you to speak to the motion that is before us?
Mr. Chairman, I've not noticed this for the first time. I remained silent in the first session. I would respectfully request that if I am given 5 minutes to just allow me to express and present the arguments that I want in a manner that I would like to do. And that's no disrespect to you, Mr. Chairman, nor the panel. I'm saying that even this morning, we're hearing you announcing requests for changes that in a confidentiality hearing that we had. And we have to give them that because we want to make sure that there's fairness on all sides, in my view. My team believes firmly that, one, Public Counsel was only recently appointed, which we have heard, and we knew the previous Public Counsel was ill. We also know that rate making is a very intense and rigorous process. I've been involved in rate making for many years. It's going to take anyone time, even with experience, vast experience, to be able to go through the voluminous amount of information. We've also known that the Public Council itself is not only dealing with rate making. I'm not sure if it was mentioned before, but all public matters. And there are going to be issues of consumer rights and matters that they still have to deal with above and beyond the rate hearing. In addition to that, you can see that the applicant, as mentioned before, is well staffed. And the applicant has recently has an interim relief. Therefore, against that background, it would be extremely difficult, Mr. Chairman, for my team and I to sit here and not support the Public Council. Imagine if we were ultimately to allow this to proceed without giving the time, and then a decision is made after X weeks, X months. And the general public see that, look, how much time has been given to the Public Council who really came into office in effect 3 days ago. That would make all of us look bad. We can't afford that kind of thing. So in my opinion, we've heard enough already. I'm not here to discredit anyone, but I'm telling you, in my view, is that ratepayers are not feeling well with a decision that has recently been made, and hence, we really have to demonstrate to the ratepayers that the Public Council, who represent their interests, has now got a second opportunity to be able to present their arguments and give the support. We as interveners, we do not have legal resources. We're extremely fortunate to have some person like Ms. Watson, who is clearly, versed with regulatory matters and legal matters. Without that, we would have been really in a most difficult position. So I would say, in summing up this, that one, the Public Council needs all the support and need the time, and therefore we, as a group, support the motion. And two, if we do not support that motion, Mr. Chairman, I'm sure that the public would be really not pleased with us by any means. Mr. Chairman, I thank you for hearing me.
Thank you, Mr. Wendt. I now invite Mr. Brown from the Barbados Sustainable Energy Cooperative Society Limited.
Good morning. Thank you very much, Mr. Chairman. As a representative of the cooperative movement, we unreservedly support the motion by Public Council. As I said, we represent large numbers of ordinary Barbadians, and in our opinion, the whole point of this public hearing must be built on transparency and fairness. Now, quite apart from the statutory requirements of the role of Public Council, which we have heard a lot and I'm not going to repeat, I would like to draw to the Commission's attention the fact that on the 22nd of August, I think it was, at that oral hearing, Light and Power had concerns about a set of dates proposed by the Commission. In response to those concerns, the Commission went out of its way to accommodate dates that were most suitable to Light and Power. At that session, we heard about the difficulties being faced by Public Council. The message that would be sent to the general public now, sir, if we were to ignore, it is not as though we are hearing today or yesterday that there's a problem in terms of changes in the Office of Public Council. We knew this for months, and we certainly knew it at the hearing when we gave consideration to Light and Power's request for change. So as I said, apart from the statutory requirement, which in our humble opinion, sir, would create serious legal challenges for the whole process if Public Council is not allowed to participate fully. Quite apart from that, in the interest of fairness and transparency, given the consideration that was given to Light and Power with all their resources, it would be remiss, in our opinion, sir, if this commission is to ignore the requests, the reasonable legal requests of Public Council to give them the opportunity to represent the public of Barbados in this hearing. I want to make it clear, sir, and we feel very strongly about this in the cooperative movement. I want to make it clear that what we see here is a very disproportionate level of representation in terms of the resources available to Light and Power, for example, the information available to the Commission, for example, when we compare that to what is the major stakeholder in the regulated public utility that light and power actually is. The major stakeholder must be the customers that actually foot the bill for this whole operation. The Public Council has a legal statutory duty to represent these major stakeholders. They're not on the board on light and power. They're not there when decisions are made about dividends or whatever decisions they make. They're not there here unless the Public Council is given the opportunity to play their full role in this public hearing. That, again, is a nail in the coffin of the general public, who I will close by reiterating, is easily the major stakeholder in the Barbados Light and Power Company, a regulated public utility. It is not anybody's private company. It is there for the public good, and the public must be properly represented. Thank you very much, Mr. Chairman.
Thank you, Mr. Brown. Public Counsel, I invite you to respond.
Thank you. I basically would just repeat what I'd said before, and actually, I'm going to comment on the point that, should have been two persons or, or even more than one person. The Office of Public Counsel is really three people. It is an investigative officer, a legal officer, and a public counsel. But the Act specifically states for the public counsel to be the one to do the representation. Also, at the time, the Commission had full notice of the fact that there was no public counsel in place. This wasn't sprung upon them. They knew far back as July that there was no one in place. So there isn't a case where they could have pulled somebody from somewhere else. There was nobody to pull. The investigative officer is not an attorney at law, and the legal officer, there was no legal officer at that point in July to do anything either. So the reality of it is, I just want to say, even when you look at the civil procedure rules, which you use in a senior, if you want to say a superior court, even when you look at that, the overriding principle is always ensuring there's fairness, ensuring there's justice, and also ensuring there isn't a disproportionate situation where one side is treated differently or treated not as fairly as another side. So I basically just reiterate what I'm saying. In order that there's no travesty of justice, in order that there is a fairness and a reasonableness, the only possible outcome of the request for the adjournment can be that it's granted. Because to me, if it's not granted, what is the message being sent to the consumer of Barbados? The Public Counsel, with a statutory duty to represent the average consumer. The Public Counsel's office was created for that very reason. You don't have much money, but you can come to us, you don't pay a fee, and we can represent you. So here it is. You have BLPC with its countless, excessive, and basically a whole lot of resources. But you have the Public Counsel now, basically one person representing all the consumers of Barbados, as well as the Barbados Association of Retired Persons, as well as the Business Development Unit, and the only reasonable, if we're looking at transparency in this whole process, the only reasonable, fair, just, possible human thing that the Commission can do, if you're interested in justice, and if you're interested in ensuring that consumer rights are protected, there's no other alternative. There's nothing else you could really do if you're interested in those things. The only thing you could possibly do is to allow Public Counsel to have an adjournment to ensure that Public Counsel is able to submit the relevant procedural documents that should have been done ever since, and also to allow a proper representation that is allowed under Section 9 of the URA, which allows for proper and complete representation of the consumers as set out as a statutory duty. I therefore close by once again reminding the Fair Trading Commission of its statutory duty in respect to the protection of consumers. And if both the statutory duty of the Fair Trading Commission and the Public Council is to be properly carried out and is to be sure and transparent, the only thing that the Commission can possibly do in this situation is to ensure that the mandatory statutory duty of the Public Council is allowed to operate fairly and allowed to be able to present arguments properly before this Commission. Thank you.
Thank you, Public Counsel. I invite Commissioner Martinez just to ask the Public Counsel a question.
Good morning. Good morning, Ms. Dean. I just have two questions for you. Can you tell us how long you will be acting in the position of Public Counsel, and what will happen if Ms. Burke returns to work before the end of the 2-month adjournment?
Thanks. My understanding is that Ms. Burke is not returning. That is my understanding, that I believe she may be going elsewhere. At this point, my understanding is I am supposed to be in the position until probably the end of December, but I can't speak to whether it will be extended, or I can't speak to that. I just know that I'm currently in the post, basically.
So that can mean that you'll be requesting another adjournment if the hearing is not set down prior to the time when you demit office. Is that correct?
No, I disagree with that, ma'am, because in this situation, once we're given the adjournment, whomever, whatever, whoever comes after me would, in this case, be properly briefed. So there would be a complete difference, because anybody who takes over from the current acting Public Counsel would be in a position where they would have all the interrogatories answered by BLPC, as they're not answered at this stage, all have not been answered. So they would be in a situation where they would be properly briefed. You see, I think you have to understand that, I remind you again that Ms. Burke became ill. So in that situation, there was anybody else in the Public Counsel's office, because there was nobody else there that could possibly take over at that point.
Okay. Thank you, Public Counsel.
Chair, if I may. Yes, I need to correct some misstatements that have been made. There are no interrogatory responses that are outstanding by the Barbados Light and Power in this manner. It has been repeated a number of times. I don't wish the record to indicate that. I will not go back over arguments from my friend Ms. Watson that have been previously tendered and have been answered, but certainly as it relates to the record, there are no outstanding obligations on Barbados Light and Power Parks.
Okay.
Chair,
Thank you.
would you permit me on behalf of interveners to respond to that? Because I think Mr. Aline is misleading the Commission. There are outstanding interrogatories, some of our initial interrogatories, and there are interrogatories that the company has failed to answer or to answer satisfactorily, including instances where it has said it does not think it is relevant. I just want to make that clear.
Okay.
Chair, we have answered interrogatories as ordered by this Commission.
Mr. Aline and Ms. Watson, the motion at hand is in relation to the adjournment, so if we will stick to the motion, I think at this time we've heard the submissions. We have from the applicant as well as from the interveners. We will now adjourn to consider the motion, and we will resume as soon as we have completed our deliberations to make a determination in the matter. So